Calling Civil Matters 18-5146, City and County of San Francisco versus Jefferson B. Sessions et al., and case number 18-5169, State of California versus Sessions et al. Counsel, please come forward and state your appearance.
Good afternoon, Your Honor. Sarah Eisenberg for the City and County of San Francisco.
Good afternoon, Your Honor. Yvonne Murray for the City and County of San Francisco.
Justice Smith for the City and County of San Francisco.
Welcome.
Good afternoon, Lee Sherman for the State of California.
Good afternoon, Your Honor. Cherokee Melton for the State of California.
Welcome.
Good afternoon, Your Honor. Scott Simpson for the defendant.
August Lungy for the defendant.
Welcome. All right. So, as we discussed before, I'm not going to change my prior rulings on issues that we've already decided, so I'm just going to be focused on the two conditions, the information and the nondisclosure conditions. I don't see a distinction that matters regarding the information provision. A distinction that matters with respect to what I've already ruled with 1373. So in my view, that would seem to fall the same way. The nondisclosure provision is different, and I'm interested in argument about that because it would seem that an unambiguous provision that protects the confidentiality of law enforcement operations would be inherent in any law enforcement grant. And if that was not obvious, if hypothetically that was not obvious in the Oakland situation, that would give the Attorney General the basis to be explicit. But the 1324 requirement prohibits an indirect attempt to conceal, harbor, or shield from detection any fugitive from justice or any alien who has come to, entered, or remained in the United States in violation of 8 U.S.C. Chapter 12, which would seem to go well beyond the hypothetical Oakland situation. And it does seem ambiguous, and the government really didn't join the arguments that the state and city made. The state posits that that provision interferes with its obligations under the Truth Act and the K through 12 model policies regarding immigration. In addition, it notes that the acting director of ICE threatened criminal prosecution of California elected officials for violating 1324. And the failure to engage in those arguments raises the specter that these conditions are just a way around arguments that I've rejected in other cases. So I'm interested in the government's, I'm interested in both sides' arguments on that. And then I'll save my view on the injunctions until later. So let me start with, I think I'd like to start with the government and hear your reactions to all this. Mr. Simpson.
Thank you, Your Honor. It's good to appear before the court again.
If
I could just start, first of all, with a little background, then I'll answer the court's questions, and I appreciate hearing what the court's thinking. First of all, to step back, I think we're here today to protect the confidentiality of federal law enforcement information that's provided to federal grantees, and I think also to protect the liaison between federal law enforcement and state and local law enforcement. That's a beneficial liaison. Law enforcement officials at different levels of government, there's a need, obviously, to share information, and they need to be able to share that information without a concern that a public official might publicize it. Disclosing federal law enforcement information in an effort to conceal fugitives or unlawful aliens obviously frustrates law enforcement operations and endangers law enforcement personnel and endangers the public.
But so my question is, in the hypothetical situation of ICE letting a local official know that they're going to have an operation the next day, and that official then turns around and tells the subjects of that operation, this is happening. That's one thing. That's a clear operation. What else does the condition reach? What other sorts of disclosures is the government concerned about, or might the government turn to the city or the state and say, you're in violation because you did X, Y, or Z?
Your Honor, if I could, let me just comment a little bit on the ambiguity argument under the spending clause first, and then I will address those specific questions about the K-12 model policies and the Truth Act. On the ambiguity argument in general, we mentioned this in our briefs. It seems like the plaintiffs are demanding greater clarity in a grant requirement than they demand of California's own statutes, including criminal statutes. Some of the state's statutes use most of the very same language that's used in the grant requirement, including publicly disclosed and quotes attempts directly or indirectly, close quote. And so, in general, the language of the grant requirement in general, we would suggest, is fairly clear. But if I could address those two specific questions, and I think we didn't address those specific questions about the K-12 policies and the Truth Act because, in my mind at least, it was fairly obvious. The K-12 policies, as I read them, are about protecting the information regarding students and their parents. It doesn't seem to address or affect the potential disclosure of federal law enforcement information. Again, the focus of those policies, as I see them, is to protect information regarding students and their parents. So I can't see how it would. I can't see how a local educational agency complying with those model policies could be found in violation of the grant requirement. And on the Truth Act, if I could refer specifically to, and of course I believe what the plaintiff, what California was talking about there, the forum requirements where local agencies have to tell their constituents, their residents, about the local government's cooperation or non-cooperation with federal immigration authorities. And it says that at those forums, they have to provide data that the government maintains regarding the number and demographic characteristics of individuals to whom the agency has provided ICE access, the date ICE access was provided, and whether the ICE access was provided through a hold, transfer, or notification request or through other means. So, as I see it, the purpose of those forums is to inform the residents what kind of cooperation the local agency, what kind of cooperation, if any, the local agency has made with federal immigration authorities. We don't see that requirement, that forum requirement, as affecting the potential disclosure of federal law enforcement information. What we're trying to protect here, Your Honor, is the disclosure of information, and again, to go back to the point regarding the language of the grant requirement in general, we have to remember as well that regardless of whether a given piece of information or a document could be said to constitute law enforcement information as defined in those rules of construction, there's also an intent element. So even if a piece of information or a document could be seen as law enforcement information under the grant requirement, the disclosure of it would not violate the requirement unless the disclosure were made with the intent to conceal, shield, or harbor an unlawful alien or a fugitive.
But who's making that interpretation?
It would have to be the Assistant Attorney General, the Office of Justice Programs. But, Your Honor, we're not talking here about criminal consequences. We're not talking about we're not talking about a local government agency no longer being able to participate in federal grant making. We're talking about the potential to lose a particular funds, a particular federal grant. And if there's any concern about, if a local government is thinking about making a disclosure and is concerned about whether this would be found to violate that grant requirement, the local government could go to OJP and say, would like to make this disclosure. Do you think that would be a problem under the grant requirement? And it's not, as I said, it's not a criminal consequence. It's not a huge thing from that standpoint. It's simply the possibility of losing grant funds.
Well, so is the purpose of the condition to reach anything other than that hypothetical situation that I described earlier? What other sorts of law enforcement information is that trying to get at?
Well, Your Honor, if I could comment just for a moment on the situation with the mayor of Oakland, that was not a hypothetical situation.
Well, so I don't know what the facts were. There was some suggestion in the briefing that she received information indirectly as opposed to directly, and I'm going to, for the purposes of what I'm talking about, I said at the beginning that situation could well lead the Attorney General to have the discretion to add a condition that is specifically targeted and narrowly defined that way. And I'm trying to figure out whether what the department wants to do is something more than that.
Your Honor, perhaps part of the answer to that is the fact that this is primarily, and this goes to the separation of powers ultra vires claim that they make as well. The authority that this is based on is primarily the authority for the AAG, for the Office of Justice Programs, to maintain liaison among different levels of government in relation to criminal justice. The purpose is to make sure, is to protect that ability to liaison. And in fact, if the statute uses the term maintain liaison, I think in looking at the meaning of that authority and the meaning of the grant requirement itself, we need to also think about the verb liaise, which obviously is reflected in that authority to maintain liaison. According to Google, to liaise means to, quote, establish a working relationship, typically in order to cooperate on a matter of mutual concern. And so we're trying to protect the ability to liaise for the federal government, for federal law enforcement, to liaise with state and local law enforcement. So
so you're making that sound like it's really much broader. That condition is really much broader than the narrow issue involved with the hypothetical Oakland situation, because the government has a perspective about the issues we've been talking about for the last year and a half, which is very different than, say, the city or the state. And if liaise means cooperating on all of those areas, then we're back into the same cauldron we were in before.
No, Your Honor, we're not talking about requiring them to liaise. And if I could just refer to the language of the grant requirement itself, it says no public disclosure may be made of any federal law enforcement information, and that's defined in the requirement later on, in a direct or indirect attempt to conceal, harbor, or shield from detection any fugitive from justice, I'm skipping the citations to statutes, or any alien who has come to, entered, or remains in the United States in violation of federal immigration law. Besides talking about the language of it, and besides talking about the fact that it defines sensitive law enforcement information, besides talking about the fact that we don't see it as reaching those public forums under the Truth Act, we don't see it as reaching what the kind of information that the K-12 model policies are intended to protect. Besides saying those things, I'm not sure how else we can limit this. I think it's very clear on its face, and again, it's not. Even if a piece of information were to fall within federal law enforcement information under the requirement, unless there were an intent, unless it were disclosed with an intent to protect a fugitive or an unlawful alien from discovery, unless it were there were an intent to shield one of those persons, then the disclosure wouldn't violate the grant requirement. And I think it is very limited. It is not, and I apologize if my reference to maintain liaison gave that impression. The requirement comes out of or arises out of that need to maintain liaison, and arises out of, it is based on that authority to maintain liaison, but it definitely is not a general attempt to force them to force the local, state or local agencies to maintain liaison. It's to as I said near the beginning, Your Honor, if federal law enforcement and state and local law enforcement are going to liaise, then and this is the same. This would be the same if state law enforcement and local law enforcement, where they liaise between themselves, there needs to be confidence that information that's conveyed in confidence, confidential information, that will be protected, and that's the purpose of the requirement.
Okay. Do you want to speak at all to the information provision before I ask for a response from the plaintiffs?
Yes, Your Honor, and we mentioned this in our brief, and I think it's an important point. We're not enforcing that requirement against California or its political subdivisions. We actually had not planned to talk about it very much. It arises in part out of the authority for OJP to maintain liaison. Federal law enforcement officials need to know that state and local law enforcement officials are not bound by any laws or policies that might affect their ability to liaise. Also, obviously, I'm sure the court saw this in the briefs. The statute authorizes OJP authorizes the Assistant Attorney General to dictate the form of burn jag applications. Obviously, the purpose of an application is to gather information. So determining the form of an application necessarily includes deciding what information to ask for in the application. Plaintiffs seem to think that is limited to something as simple as whether the date of the application appears on the left side of the page or the right side of the page. But obviously, there was no need for Congress to enact a statute to allow OJP to dictate that kind of thing. And, Your Honor, I understand, and we did say in our briefs, that the purpose of that information sharing requirement is primarily to determine whether a grantee can abide by the notice and access conditions, and we certainly understand that the court's earlier ruling on the notice and access conditions from 2017, that ruling does apply to the similar requirements in 2018,
Okay, I just wanted to be sure that was where you were.
Absolutely, absolutely, Your Honor. We understand that. But in addition to that purpose of it, it does also, providing that information does also inform whether the grantee will be able to maintain liaison. Because if there are laws or policies that affect their ability to work with federal law enforcement, then the federal law enforcement needs to know that. Needs to know that the state or local agency is affected by those laws or policies at the local level.
Okay. All right. Thank you, Mr. Simpson.
Thank you, Your Honor.
Who's first? Mr. Sherman.
Thank you, Your Honor. And my colleague Cherokee Melton will be addressing our APA claim and anything regarding any questions regarding injunctive relief that you may have. So the first question that this boils down to is whether defendants have the statutory authority to impose the 1324 requirement. And defendants have only identified the same statutory authorities that you reviewed last year and that you found were deficient with respect to those conditions, including the maintain liaison provision in 34 U.S.C. 10102A2, which you noted in page 40 of your opinion does not justify those conditions.
This seems, if in its narrowest form, this condition seems so fundamental to the relationship between federal and state and local law enforcement, it's hard for me to see why in its narrowest form, and I'm not sure that it's there, but why that wouldn't be an appropriate thing. And you're just telling me that there's no that there's no statutory authority, so it can't possibly be part of the grant condition.
Well, their statutory authority comes from an administrative provision, which, if you Gonzales v. Oregon, that Congress does not place such broad authority into an administrative provision. And Congress wanted to impose a condition like this, particularly with respect to immigration enforcement, which is not at all part of JAG's purposes. Congress would have done so explicitly. And to give you an example, Congress has actually added a condition regarding the confidentiality of data, and that is found in paragraph 36 of the state's JAG award, and that's tethered to 34 U.S.C. 10231. But that provision does not expand so broadly as defendants are seeking, which is to encompass any law enforcement information, which embodies any request that is made by law enforcement. That provision is regarding research and statistical data, and that should be kept confidential. So where Congress has already spoken about confidentiality of data, and defendants are seeking to go around that through an administrative provision to provide it the authority to add this requirement with the breadth that it has done, that is not something that Congress has intended and something the defendants cannot rely on for this condition.
Well, the state wouldn't disclose information that it received about an operation that that federal law enforcement was about to commence, where the lives of law enforcement is on the line, and the possibility or probability of deconfliction or lack of that could create a problem for everybody. The state wouldn't be against that, right?
You're correct, Your Honor, that the state's laws and policies do not conceal, harbor, or shield, or do what's suggested. Nonetheless, this is a fundamental aspect of separation of powers, is that there still needs to be statutory authority for that condition. And
why would it make sense for the federal government then to provide a grant to the state if the state wasn't going to do what seems like such an obvious appropriate thing?
Understood, Your Honor. The state's position is that there still would need to be statutory authority. In any event, the breadth and the ambiguity of this condition does not, as you were alluding to, goes much broader than that. And what defendants do not discuss is that they acknowledge in their brief that Labor Code Section 90.2 falls within the scope of this condition. And that is a notice provision that employers are required to provide to employees certain notices about I-9 eligibility verification forms and if there's inspections that are occurring. And that provision, first of all, is is not within the scope of the program or activity to be funded, which raises concerns both about the ambiguity and unrelatedness. But it shows to what defendants are really getting at here, that it's not just this one incident or this hypothetical that you just raised, that it's something much broader than that. And the K through 12 model policies, while they do provide for certain protections for student and family information, under certain circumstances, they do, like Labor Code Section 90.2, provide information to families about immigration enforcement requests that public schools may receive, and that's similar to what's in Labor Code Section 90.2, in which the United States and U.S. v. California said was a warning to non-citizens. And so that is the concern both with the ambiguity and the breadth of this condition, that it isn't just with this one hypothetical that either the Mayor Schaaf situation or the situation that you just raised. In addition to which, defendants also suggest that this is that there is an intent requirement. The language of the condition belies that, though, because it conditions funding on an indirect attempt to conceal, harbor, or shield.
It's an intentional indirect attempt.
But again, that goes to the ambiguity of what we're talking about. And the state statutes, first of all, those are state statutes in which juries and courts can interpret their meaning, not the AAG, as defendants acknowledge would be the arbiter of of who's going to be deciding whether a jurisdiction complies with the condition or not. But in any event, the state statutes are not conditions on funding. They do not have to comply with the Pennhurst test that requires clear notice to the state and localities in order to provide funding. So that, too, is another reason why the ambiguity of this condition is so concerning. Those are the only the points that I would like to make, unless you have any additional questions, Your Honor.
No,
okay.
Thank you.
Thank you.
It's always easy to go third. I can be brief. So I have just a few brief comments to make. I think what's tricky about this condition is that it feels somehow in its narrowest form, at least. And as you said, I think we're all concerned about whether this is in its narrowest form. But in its narrowest form, it feels somehow more reasonable. But we're not here, as Mr. Simpson said, to protect the confidentiality of law enforcement information. We're here to ask whether, under separation of powers principles, DOJ is allowed to attach this as a condition to a formula grant. And so the test isn't reasonableness. The test is, was this explicitly authorized by Congress? And the only authority that DOJ has pointed to for that is this notion of maintain liaison. And when you look at that provision in context, that provision gives OJP the right to maintain liaison and provide information and create relationships with a whole host of different bodies and representatives and people, the federal courts, the executive branch, state, local government. And the idea that that is an express grant from Congress to DOJ to impose this condition on a formula grant and then act as the unilateral arbiter of what the local or state government's intent was in disclosing that information, to revoke funds that were allocated by Congress, just strains the reading of that provision. So I'm not standing here saying that this condition standing alone somehow violates the Constitution or is unreasonable, or that if DOJ came to our police department and said, I'm going to give you this information, but only if you sign something saying you're not going to disclose it, that would be unreasonable. But what we're saying is that it's just not authorized by Congress for them to do on this grant.
Doesn't it strain your credulity to think that when Congress was authorizing a criminal justice program, that they would think, just as a matter of course, the city and county of San Francisco would not disclose some criminal law enforcement operation happening the next day. Don't you think that was just sort of part and parcel of any grant that Congress would make of federal money to locality?
I mean, there's just no indication that they were thinking of it as relevant to giving out this grant money one way or another. Certainly, DOJ could, before they give information, impose confidentiality conditions. But you can't sort of imply or just believe that Congress must have been thinking about this. Your Honor has held that Congress can delegate the authority to impose conditions to an executive agency, but they have to do so expressly.
It's a different kind of a condition in my mind, but anyway. But I do understand the argument that you're making so far. So go ahead.
And I guess the only other point I would make is that to the extent that Mr. Simpson has argued that this maintain liaison provision is the linchpin of it, that somehow that gives them the right to impose not just the nondisclosure provision, but also the information sharing provision. This is now sweeping very broadly. If that is the hook that they are hanging their hat on, then that exception sort of swallows up separation of powers principles. If they can use Congress's general statement to maintain liaison with state and local government to justify both of these actions, then again, we're in a situation where they can use this to basically subvert Your Honor's prior ruling and all of the separation of powers principles that we've been talking about for the last 2 years.
Okay. Thank you, Ms. Atwood.
Thank you.
Thank you, Your Honor. Just a few final points, if I could. I think some of the Court's comments reflect this first thing I'd like to say. I think it's remarkable that California and San Francisco seem to be trying to defend the ability to disclose, or they're trying to retain the ability to disclose federal law enforcement information at will as a federal grantee.
I don't think that's what they're doing, Mr. Simpson. I think they are trying to protect their powers and rights, as they have been for the last 2 years, against a government that has the federal government, which has a very different perspective about it.
Your Honor, retain and protect what here? We are looking, what we're considering here is the publication, the disclosure of federal law enforcement information. It seems, again, it seems remarkable as federal grantees to try to protect their ability to disclose. Let me mention another word that I don't think has been mentioned yet during our time together here. That is deconflict. I
mentioned it.
Oh, I'm sorry, you did. In law enforcement circles, deconfliction. It's the when a law enforcement entity is going to go in, do an operation with firearms, going after people who may not want to be found or may not want to be apprehended. There's a need to deconflict, to let other agencies that work in the same area know about the operation, so that the agency receiving the information about the first operation doesn't think that criminals are involved, doesn't think that doesn't send in their own personnel to stop the operation, that kind of thing. It's a need to deconflict. In fact, OJP itself promotes resources and systems for law enforcement deconfliction. On its website, they have information about deconflicting. And if federal law enforcement can't deconflict, and that's what happened as I understand, in the Oakland situation, if federal law enforcement cannot deconflict their operations without a fear that the operations are going to be disclosed publicly before the operation, that greatly hinders the federal government's ability to engage in those operations. They have to be able to deconflict. And one final point, Your Honor. If the court is concerned about the scope, the possible reach of the public disclosure requirement, we would suggest the court can make a narrow interpretation of it and say that within this interpretation, I find that the requirement is permissible. If it goes beyond that interpretation, then I find that it is not permissible. And we would suggest that, obviously, the kind of situation that we've talked about, the Oakland situation, I think the court believes that that application would be permissible. And so the court's ruling could make that observation and say that the requirement is permissible to that extent.
And then you'd probably agree that I could make a nationwide injunction based on that, would you, Mr. Simpson?
Your Honor, on the nationwide injunction, and we recognize that the court has entered a nationwide injunction previously. If I could, if the court would like, I could make just 3 points, if I could, about the nationwide injunction issue.
Well, so I wouldn't make, I'm not sure that it helps because with respect to the information provision and what's already out there, I've made my determination. The Ninth Circuit's going to take a look at it. I'm not going to change my mind. I'll be very interested in seeing what they do with that, but that record is that record. With respect to the 1324 disclosure issue, I'm not inclined to include that within, and I'm happy to hear your argument on this, I'm not inclined to include that as a stayed nationwide injunction if where I come out is ambiguity. Because I think the issues in California are going to be different than in other places, and so that's basically my thinking at the moment on that.
Certainly, Your Honor. If I could just make a few points about the nationwide injunction issue. Obviously, these 2018 conditions, aside from the 2017 conditions, these 2018 conditions and requirements are pending in a number of other cases as well. And so, obviously, if there were a nationwide injunction here, or to the extent there were a nationwide injunction, it could affect those other cases. It would be especially difficult situation if the different courts entered conflicting rulings, obviously.
But if I enter a nationwide injunction and stay it as I have before, then the courts will deal with it as the courts
Correct.
deal with it above me. Yeah.
Correct, Your Honor. If I could just, the court mentioned we've actually talked about a number of different terms, and terminology sometimes is just semantics, but sometimes it is important. Here, I think terminology actually is important. I made myself a little table of the different terms that the different parties use for these two requirements we have here. We're calling them the public disclosure requirement and the information sharing requirement. That's pretty much what San Francisco's calling them. California is calling them by very different names. They're calling the public disclosure requirement the Section 1324 requirement. We would suggest that the court not use that term. The 1324 is the statute that sort of prompted OJP to impose this condition, but really it's focused on protecting information and preventing the disclosure of information with the intent to conceal or harbor or shield an alien. But it's really the term 1324 requirement suggests that we're requiring the grantee to abide by 1324, which we're not.
Okay.
Thank you, Your Honor.
Thank you.
I have just a few quick points in response, and then my colleague, Cherokee Melton, will address a few things.
Okay.
First of all, on the 1324 requirement point, Mr. Simpson just said that that 1324 is what prompted this condition, and that goes back to the statements from former Director Holman last year, seeking charge state and local governments with violating 1324. And 1324 is a law that doesn't even apply to states. Nonetheless, California, though, doesn't conceal, harbor, or shield anybody. And as you know from the 2017 litigation, California cooperates extensively with federal law enforcement on criminal justice matters. But the issue here is, as you pointed out, is the sweep of this condition, that it goes into legitimate state interest at transparency. That's at the heart of the Truth Act, and that's at the heart of the K through 12 model policies. And I suggest, as you probably have done, looking at the LAUSD amicus brief and the evidence that we put forward, in which, because of the heightened fear of immigration enforcement, children are finding it more difficult to pay attention in school, and are finding it, and families are concerned about enrolling their students in school. And that's what the K through 12 policies are intended to address. And that's where the legitimate state interest that is impacted here. And the third and final thing that I want to say is that defendants reference the goals of deconfliction. As decided in Arlington Center School District Board of Education v. Murphy, the federal goals in of itself is not sufficient to justify a condition for funding. It again has to come from the statute. And defendants have not provided any statutory authority that credibly can justify this condition. And while Congress has imposed other conditions on confidentiality of data that doesn't have this broad scope.
All right. Well, so, and what do you think of Mr. Simpson's idea that I should write the condition for the department?
California does not agree with that approach. The condition is unlawful. The proper remedy, and my colleague, Ms. Melton, will address that. The proper remedy under the Administrative Procedure Act is to set aside the condition, in addition to which, because of both the statutory authority and the spending clause, the condition is unconstitutional. So the condition must fall.
All right.
Thank you.
Thank you.
Very briefly, and then I'll turn it over to our colleagues to talk about the scope of the injunction. First, I appreciated Your Honor's response to Mr. Simpson's first comment, and I wanted to just reinforce on behalf of the City of San Francisco that we are not here saying that we have any intent, nor would we, disclose law enforcement confidential information that we received directly from the federal government that the federal government told us not to disclose. That is not what we are here fighting over, and I did want to make sure that that was clear to everybody. And then turning to the idea of rewriting this, we are here because we are concerned about what else falls within it and what our rights are. And it is not the court's role to rewrite a condition that an executive agency imposes.
Sometimes it is. I disagree with you there, Ms. Eisenberg.
Well, particularly here, there are so many ambiguities here that haven't even been discussed in the context of this court about whether information that comes directly from that does not come directly from the federal government is covered. DOJ took conflicting positions on that, it appeared in their briefs. The ambiguities are so sweeping that for this court to try and rewrite it at this point does not make sense. And so the condition should either rise or fall on what is written on the paper.
Okay. Thank you.
Cherokee Melton for the state. Your Honor, I'm going to speak briefly about the APA claim.
Okay.
And with respect to the 1324 condition, and I'm sorry, I don't remember what defendants requested we call it. Again, whether or not defendants have a legitimate interest in protecting certain law enforcement information in certain contexts, that may be a legitimate interest, that may be a laudable one, but that's not the test here. With respect to the APA claim, the court should evaluate this condition through the lens of State Farm. And it's clear that defendants have entirely failed to consider the problems that flow from the application of this condition, and in particular, the breadth of the application of this condition. There is nothing in the record that speaks to how to reconcile how the breadth of this condition with state laws and policies that encourage or require transparency.
What if I interpreted it really, really narrowly? What happens to your APA claim?
Well, 2 points on that, Your Honor. First, I would argue that although defendants have spoken today about the condition in a very narrow fashion, that is belied by the arguments in their brief, and again, the record itself. bringing up issues like 90.2, which they did in their reply in the APA section as an example of California's, quote, laws and policies that support this condition. In terms of the remedy, the Ninth Circuit says that the standard remedy, if you were to find the condition was unlawful as written, would be to set it aside. And only in limited circumstances would the court do something else. When deciding whether or not the court would do something else, like remand it, for example, you would need to look at the seriousness of the error as well as the disruptive effect. Here, the error is serious. The condition violates the Constitution. There's no statutory authority. In terms of disruption, Your Honor has already issued a nationwide injunction, and in this case, the grants have gone out. So there would be no disruption in setting aside the condition. If this court felt that that's what it needed to do, that would be the proper remedy.
All right.
Thank you, Your Honor.
Thank you.
Sure. Yvonne Murray for the City and County of San Francisco. Your Honor, one quick last point just on the nationwide injunction issue. Defendants argue that Article 3 should serve as the bar to the parties, to the state and the city seeking a nationwide injunction in this case. But they point to no case that makes that point. And I guess that the way that the city and the state conceive of it is that the nature of the violations here are constitutional in nature. It is undisputed in this case and the previous case that this court heard that the Burn JAG program is instituted nationwide, and therefore the program and the conditions are applying equally. Now that's not to say that each jurisdiction uses the funds differently, but when my colleague at DOJ suggested that this court take a narrowed view, I had the same question that this court had, which is why then does that not invite a nationwide injunction? Again, the issues that are before this court, certainly the court has the discretion, both sides agree with that, and certainly the DOJ attorneys agree that should violations be found, that San Francisco would be entitled to a permanent injunction. Here, I guess that San Francisco argues that given the nature of the violations and given the administration of this program nationwide, that the court is certainly within its power and the facts support the award of a nationwide injunction.
All right, thank you. Mr. Simpson, do you want to have any last word on any of this?
Thank you, Your Honor. Just two very brief points. We're not asking the court to rewrite the requirement. We're asking for guidance. We're asking, we're asking the court not simply, if the court is inclined to strike down to hold that some aspect of it is impermissible. We would just ask the court for guidance on what the court believes would be permissible. Just one point on the nationwide injunction point, Your Honor. One of the things that I believe both of the plaintiffs filed this, filings, declarations from other cities out there. Obviously, the fact that the cost of litigation for some Burn JAG applicants would be greater than the amount of their Burn JAG award we believe would not justify a nationwide injunction. Potential litigants in the United States often decide to forgo litigation because the potential benefits don't justify the cost of litigation. That's our American system. The remedy would be a class action where that's appropriate, and the plaintiffs haven't asked to make these class actions.
All right.
Thank you.
Thank you. Thank you all again and for your arguments, and I'll try and get an order out as soon as I can. And I will just say, because these are two former colleagues that I had in the department, it's a pleasure to see both of you, and give my regards to those who should get them.